Yes, Mr. Chair.
Just calling the committee to order, and please take the roll call.
And just a reminder to all who are in attendance, this meeting is being live streamed and recorded on the county's YouTube page. Calling the roll, Mr. Sweeney.
Present.
Ms. Simon. Simon is absent at the moment. Ms. Baker. Mr. Miller.
Here.
Mr. Schrein.
Here.
There is a quorum.
Thank you, Madam Clerk. Today we're here to discuss ordinance number 0201, an ordinance amending Cuyahoga County's code sections 40601 and 40602 to clarify the contents of the Cuyahoga County whistleblower provisions. Would the interim inspector general please come up?
Excuse me, Mr. Chair. We do have one person signing for public comment.
Rookie mistake. If I do it again, I get penalized. Lou, I apologize. Please come on up. Welcome.
Good afternoon. I'm so happy to attend this meeting in January. I mean, our first meeting for this particular committee. And definitely, I'm here to support Inspector General's office. They have been doing a very good job to help us out, not only to clean up the mess left from the past, and also trying to improve lots of things we can do to prevent future incidents. But I'm also here to hope this committee will pay attention to the fair invasion decriminalizations, which is a very urgent need for our public transportation issues. Of course, City of Cleveland is the one having the silliest ordinance about that, but we also found out there are other cities in our county having something similar. So if we can have a proper legislation or some kind of ordinance to bring up the issue, maybe it will help the overall situation. In that case, all the people in the counties can enjoy GCRTA service without bearing the unintentional mistake which caused the serious consequences, overboard consequences. Thank you very much.
Thank you, Lou, and I look forward to working with you on the transportation issue. And I believe all of us do. Madam Clerk, thank you. Approval of minutes from November 16th. Has everybody read them? Is there a motion to approve them? Thank you. Is there a second?
Second.
Thank you. With the approved in a second, all in favor?
Aye.
All opposed? No opposed. Madam Clerk, the approval of minutes pass. Now we can get to the matters referred to the committee. Ordinance number, go ahead. I'm sorry.
And also like the record to reflect that Councilwoman Simon is in attendance.
Actually, I've been here, yep.
Ordinance number 2020-0002, amending sections 406.01 and 406.02 of the county code to clarify contents of the whistleblower provisions.
Thank you. Today we're going to talk about the whistleblower legislation that's been around for a long time. And it's my understanding that it's been worked on through the prior Inspector General significantly with my council colleague or our council colleague, Dale Miller. And I'd like to bring up the interim Inspector General, Alexa Belair. And for introduction first of yourself, you can take your mask off if you're comfortable. And then we can get on with the legislation. Thank you.
Good afternoon. Thank you for having me. I was appointed 1 week ago. So while I fully support everything that's before you today, I cannot take credit for it. That is, like you said, the work of Mark Griffin and Councilman Miller. I'm here for any questions that I will answer to the best of my ability, but
I'd like to just start off with the amendment that we're going to be offering in regards to the elimination of one word of the legislation. Councilman Miller, should we move that first?
I think when I move the substitute, I'll move a version of the substitute that it includes that amendment, and I will explain it.
Thank you very much. So, welcome aboard.
Thank you.
We're good, and I think Dale's going to start off with the explanation of how this legislation began and where it is right now. So
Great.
thank you.
Thank you.
Okay, thank you very much. First of all, I would like to also congratulate Ms. Beeler on her appointment and wish you the very best of success. My colleagues, the purpose of this ordinance is to update and strengthen our whistleblower protections. This legislation originated following comments from our former Inspector General, Mark Griffin, that our current legislation could be significantly improved. This legislation has a pretty long history. It started before COVID-19. A first attempt was introduced and heard in committee but held for additional consultations, which turned out to be extensive. The consultations involved the Inspector General, the Law Department, council, legal staff, and me. The former Inspector General supports this legislation, and our interim Inspector General supports it as well with one amendment, which I'm going to discuss in a little bit. The Law Department did not opine on the policy, but approves of the legislation as legally sound. This ordinance is therefore a substitute for the original proposed ordinance 2020-0002. So after my presentation, I will move to substitute. The updated version has 5 major features. First, the legislation provides a definition section, including definitions of whistleblower, whistleblower complaint, retaliation, and retaliation complaints so that our meanings are clear. Second, and related to the first, the ordinance clearly distinguishes between a whistleblower complaint and a retaliation complaint. A whistleblower complaint is the initial action by a whistleblower in identifying action that is illegal, unethical, or inconsistent with proper performance of duty. A retaliation complaint is a complaint made by a whistleblower that he or she was retaliated against for making a whistleblower complaint. Third, the legislation provides that a whistleblower complaint or retaliation complaint may be made either in writing or verbally, as opposed to the current version, which requires a written complaint. This change will help whistleblowers who are fearful of retaliation, therefore encouraging more whistleblowers to come forward. Fourth, the legislation more clearly defines how retaliation complaints are handled and describes the range of possible remedies. Such complaints will be heard by the Personnel Review Commission. The legislation does not prescribe specific remedies, but states that the remedies may include one or more of the following: actions that correct the effects of the retaliation, compensatory damages, and punitive damages. Fifth, the legislation clarifies that a whistleblower complaint may be made to the employee's supervisor, to the Inspector General, or to the Human Resources Department. All retaliation complaints are to be made to the Personnel Review Commission. The legislation also extends protections against retaliation to former employees for any violations that occur within 30 days following separation from employment. So our new charter form of government does not come with a guarantee against improper behavior in public service. Rather, it comes with an enhanced system of checks and balances designed to ensure that problems come to light quickly and are effectively dealt with. This legislation upgrades these tools by providing more flexibility and greater protections for whistleblowers, and I ask for your support of the legislation. So now, I'm going to make a motion to substitute the 2020-0002 from 2 years ago with the upgraded version, which you have in front of you, the version marked clean copy, and I'm moving to substitute it with one change as recommended by our new Inspector General, which is on page 2 in section C. It says, whistleblowers who reasonably believe a violation of any county, state, or federal ethics law, rule, regulation, ... We're simply going to remove the word ethics. And the reason for doing that is that it broadens what a whistleblower can complain about. It could be more than an ethical violation. It could be malfeasance, improper performance of duty, negligence. It could be a variety of things. And so this, the Inspector General's amendment simply broadens the scope of what a whistleblower could complain about. And also, I see one other thing which will, it's technical in nature, but while we see it here in section C, it says whistleblowers who reasonably believes, whistleblowers who recently believe. It probably should be believed to go with whistleblowers being plural in the first word, so we'll make the grammatical correction as well. So, with those two changes, I would like to move to substitute and make this version the version that's before the committee and ask if I have a second.
Second. Thank you, Councilwoman Baker. Any discussions? So it's just going to read to my colleague, whistleblowers who reasonably believe instead of believes. We're eliminating the S for grammatical correction. Okay.
And also, the word ethical in line 2 is also removed.
Yes.
So
okay, for this, for
that was Ms. Beeler's amendment. The word ethics is removed in line 2 of section C so that we broaden the scope of what the whistleblowers can complain about.
we had a first, we have a second. All in favor of accepting the amended version, please say aye.
Aye.
All opposed? None. Now to pass the legislation itself.
I will make a motion to refer substituted ordinance 2020-0002 to the full council for second reading.
I'm sorry, Mr. Chair, aren't we having discussion
Absolutely.
after this?
Yes.
We're going to refer it?
We just passed the substitute,
Right.
and then I asked if there was any discussion. Now we're going to move to a first and a second, then we'll have discussion about the
Okay.
legislation
Okay.
before we move forward, if that's okay.
Second.
Second. Discussion?
Am I the only one at this point?
Yes, we have a substitute bill
Substitute.
looking for passage under second to suspension, or second reading suspension.
Okay.
Councilwoman?
A couple things. I would purport and suggest that this has been looked at and discussed for 10 years. When we started the new government, we spoke at length in several months in committee about this provision in this ethics ordinance. And one of the issues was whether there's going to be reporting allowed verbally, which would come with it protection, the whistleblower protection. And it was the majority of that committee that said no. I think colleague Miller recalls that discussion at length. So this is really not a new discussion, but with new participants. And one of the reasons that was not embraced was because it would be there would be no record of that reporting, that it would be a lot easier to just simply say something's going wrong and put somebody, an employee, at risk of having great damage done as a result of that and no record. And with regard to the protection of whistleblower for a retaliation claim, the problem was that there was no record, that the reporter would simply just say, well, I said X, Y, and Z, and I'm entitled now to whistleblower protection, but there's no record of what was actually reported to the Inspector General. These were the discussions we had and the concerns we had. So I just wanted at some point to talk about that with staff, about what their position is after working on this, how that would be resolved with regard to having a record if somebody complains about retaliation. But before that, I'm curious about Section E, which took out an obligation of elected officials to report. And I want to ask Councilman Miller about that. I see lines through that on in definitions, I think.
If it's under E.
Second page. It's the second page, because there's lines drawn through that obligation, and we didn't talk about that when we talked about everything that was being substituted and amended.
Mr. Chairman, could I ask Brendan to help us with that?
Please introduce yourself.
Good afternoon, Mr. Chairman and Committee. Brendan Doyle, Special Counsel to the County Council. Councilman, what is your question with regard to the new Section E, or?
Yeah, I guess just maybe my version of this just took out the obligation. Is it there in a different way?
The new Section E discusses the obligations of the whistleblower for purposes of enforcement and interpretation. It also discusses that a whistleblower will be protected for any violations reported within 30 days after separation from the county.
Where does it say, because in sections, the old section A and B, it talks about an obligation to report. And I guess I just don't see that similar language being carried on. Is that the intent, that it would be carried forward, that anybody who knows of a violation of anything has a duty to report, because that's what exists now?
That's correct. The intent was not to remove that obligation. And no, the intent was never to remove that obligation. The whistleblower would always still be obligated to report any violation. But I see what you're saying, that there does not seem to be similar language regarding that obligation. It certainly was not the intent to remove that obligation.
Okay, because it's crossed off and it's not carried on.
Understood.
And it's not necessarily even a whistleblower per se, but it's, I guess, is any reporter now a whistleblower? Is that-
Any employee would be obligated to report.
But would they necessarily be a whistleblower now? It seems like what will happen is there's an obligation to report that wasn't carried forward, but the intent is to do that, and that anybody reporting would then have this protection regardless of the method or manner in which they make that
That's
complaint.
correct. That is correct.
So we need to do work on this to, if the intent is to carry it forward, we probably need to somehow add that back in or make it whatever version is desired.
Understood, and we can certainly include that that obligation language in the I guess substituted legislation.
Yeah,
So,
thank you for that. Just on that particular comments, I appreciate it. Are you asking to hold it, or can we do it right now after Dale talks?
Up
Can
to
you
Dale
respond?
in the chair.
I just want to know what you're
Chairman?
asking, though.
Mr. Chairman, this, This legislation has been in consultation for 2 years. I did not expect that when I brought it today. I was hoping that we would get it substituted, but I did not really expect that we would get it passed out of committee to the full council, and I offered the motion when that seemed to be asked for, but in light of the questions that you have raised, both wanting to have more discussion about the question of verbal complaints, which we discussed at great length with lots of people, but there can be more discussion, and also this technical issue that you've raised. I would be perfectly happy to withdraw my motion and let the chairman hold it over to the next meeting. I want to feel when we pass this out that it's right and good, and hopefully we can get it all together on the same page. And if we can't, we want it to be thoroughly discussed. So I have no problem with that at all.
Thank you very much for your presentation. With that being said, we're just going to hold legislation 02022-0002 until the next meeting, which I anticipate will be 2 weeks from today.
I have other questions, too.
Absolutely.
Okay, thank you.
I just wanted to
Thank you.
get that off the
Okay.
floor is yours.
So I guess this would go to Councilman Miller and/or our new IG about whether there's actually been problems with the problems that might have occurred with people reporting by way of the hotline, the hotline, whether there's been a problem with the callers being retaliated against over the past 10 years. Is this a problem that we've seen?
I would need to look more into that to see
Okay.
just what kind of problems we are looking at or what we have seen in the past. I'm
I would-
obviously brand new to
So
the
that would be a
role, but-
question that I have,
Yes,
because the
and I can actually
scenario,
find that
this,
out.
I think, is situated and geared to address would be a situation where a caller calls the hotline and an oral complaint is made, a report, and then that person who makes the call does not, in the existing legislation, have whistleblower protection from retaliation, so they couldn't come back and file or whatever they do procedurally to report a retaliation complaint. So that would be the context, which would occur over 10 years that we are now trying to address. And I want to see if actually there's been a problem with this scenario, unless there's other scenarios that I'm failing to see, which I'm sure I will be informed about at some point by our legal staff. But so I would like to know that too when we come
Okay.
back, Mr. Chair, if that's okay, to see if
Absolutely.
that has come
Okay.
up.
What we're just asking, go back,
Yes.
talk to your workmates, get as much information about the very specific question. And
Okay.
I'd like to get the information as well and deal directly with Councilwoman Simon.
Okay, and I'll share that with you
Chair,
before.
if I may, too, as former chair of this committee, through the documentation of the semi-annual reports, there is a very detailed chart that shows how the complaints come in, whether it's from the public, whether it's from the employees, whether it's done through email, all the different communication ways of sending that complaint is documented in those semi-annual reports. So it'll be an easy look to see, whether or not, I guess the question would be, how do we know who is afraid to call in if they're not protected? How many calls aren't we getting because they're fearful that that phone call can be traced back to the person who made the complaint and has no protection because of it? That's a question that we won't really know because you can't trace that. But as far as tracing the existing calls, it is documented, easy to find. You can look at any of the semi-annual reports.
Thank you for your historical perspective.
Mr. Chair, to my colleague, the issue isn't how we track calls. The question is whether those calls that are tracked, has there been an issue with retaliation and some allegation that they're not protected because they were whistleblowers. That's the issue, not how they came through, but the calls that were made, whether there's been any allegation of retaliation for making that call. And I understand your point that we won't know, how many people were afraid to make an anonymous call. That it's an anonymous hotline. And, that's important that stay like that. And if we have an anonymous hotline, how do we then designate somebody as a whistleblower? I mean, it's the opposite. If somebody's really, that's another quandary as well that we discussed. I mean, this is a hotline that anybody can call without having, they're anonymous. But with this whistleblower provision, if we add them in, they are no longer anonymous. They're going to have to state, who they are, and then they are set up to perhaps become a whistleblower and perhaps be retaliated against. So the purpose of that hotline was to allow for anonymity. But what this does, I think it takes that away to some extent. If we're going to designate somebody calling in as a whistleblower, at some point they're going to have to identify themselves in this process to become a whistleblower by definition. And how will they know that? Do you know what I mean? So it puts them in a position that they're no longer anonymous, but yet then they get a protection of whistleblower, and at some point they're going to have to say who they are and stand up, perhaps at a hearing, if they're being retaliated against. So
For purposes of a retaliation complaint, there is a requirement that the complainant not be anonymous. And I believe that existed in the current code. So no, if a complainant is anonymous, if he or she chooses to be anonymous, they are not afforded the same rights that a whistleblower who is identified would be afforded for purposes of being able to file a retaliation complaint. It does require that the complainant not be anonymous if he or she believes they've been retaliated against and wants to file a retaliation complaint with the PRC.
can a whistleblower, so anybody who calls and they're anonymous will not be a whistleblower up until in such time that they actually identify themselves in a retaliation hearing? Or
They would not be able to, if they were for purposes of retaliation, no, they would not be afforded those same rights because they would be anonymous.
But are they a whistleblower by calling anonymously? I mean, by definition, isn't a whistleblower provided retaliation protection?
Yeah, so what whistleblower should be, the intent is certainly to afford that complainant whistleblower protection.
So I think we have to add that they can't be anonymous. That's just for us to talk about through this process. I'm just raising that because if somebody's a whistleblower, by definition, they have protection. But if you make a call to this hotline and you're anonymous, they're not a whistleblower. So we've got to distinguish that. Is all I'm saying.
As it's defined in the proposed legislation, the anonymous complainant would be considered a whistleblower under the definition. However, he or she, to your point, would not be afforded protections for purposes of if that person were retaliated against, being able to file a retaliation complaint. That's correct.
So we just need to make sure all that's clear.
Well,
Mr. Chairman?
I'm done. I'm just raising these questions for us to discuss and look at.
These are very valuable questions, and I think it's very important to distinguish between a person who makes a complaint verbally as opposed to written, and a person who makes a complaint anonymously. Our intent is that a person could be a whistleblower and make their complaint verbally, but not be anonymous. Now, if they call and they just call on the hotline and make a complaint, how could they be retaliated against because of that complaint? Because theoretically, nobody should know about that complaint except the Inspector General's office.
I can tell you when you're done.
But still, I think such a person could be a whistleblower and could make a retaliation complaint if somehow it occurred, like if there was a leak in the Inspector General's office or whatever, or if someone after the investigation took place, someone surmised that it must have been so-and-so. Well, it could be that kind of a situation, and I think that person could file a retaliation complaint. But if they did, I would certainly hope that at the same time that they called the hotline, that they also wrote something down for their own personal notes about that they called and what they said. Otherwise, I'm not sure how they would prove under any reasonable process that they would, in fact, the person who made the anonymous whistleblower complaint. So I think there would be some burden of proof, but it could happen.
Yeah, I know. I mean, it's just, and of course, I mean, if two offices are side by side and they're the only ones in that area and somebody's leaving early or coming in late every day, and makes that call that they witnessed it, you know, you're right. I mean, there's a conclusion that will be drawn by the person being reported that it's probably the person next to them. And if there's retaliation, then that person's going to have to step up and identify themselves at that point. But, you know, we have to look at the language and make sure that that's, you know, flushed out. But yeah, there's ways for somebody to know who's reporting without a leak in the IG's office.
Right, okay, thank you.
Thank you. We're going to hold it, but just on the lively debate we had right now, I, as the chairman, let my colleagues down. I don't normally, it's my first time, but in the future, I don't like bringing things, I say half-baked, but in this one, it's pretty much baked until it's ready to be vetted full-time. So I should have chatted with you prior, I should have chatted with you, and I should have chatted with you, and I should have chatted with you, and it's on me. It won't happen again. So with that said, this meeting, any miscellaneous business?
Mr. Chair, I would just like to say that I welcome the discussion in committee. I mean, you're right that, you know, but this is what committees are for, to talk about it. But yeah, I think what you meant is sending it off for second reading out of committee. But yeah, this is good.
No, absolutely, through our presenter, since you're there. It's just the way I want to do business. I want to know what's coming. And I chat with you. You'll tell me, Marty, I got some questions, or Chairman, or whatever you want to call it, prefer Marty. So I'm prepared, and then I'll get into the legislation, which I should. So just sharing my thoughts with you.
Mr. Chairman, I echo Ms. Simons, because quite often it's here that you pick up these pieces of information, I believe. And I respect the chair's desire to hear what other people are thinking, but the open and free discussion, I really believe this is the benefit of this forum for us. So I would not having been involved with school boards, sometimes they do pre-meeting information, and I just did not like that. I prefer this, to encourage it. So even if you might hear it, I would love to make sure that that voice gets heard in this forum here.
No, absolutely. I'm just relating to, from my own personal, as a growth opportunity for me. I'm going to check with all my colleagues to see if they have, I don't need to know the issues. I just want to know if they might have an issue to talk about, so I'm prepared. I just assumed this was going to be okay, and I didn't do my homework. That's on me. So that's all I'm sharing. I like robust debates because it makes legislation even that much more effective for the people of Cuyahoga County that we're entrusted to take care of. Leave it like that. Is there any miscellaneous business? Hearing none.